Hey everybody, I hope you're doing well. Woke up this morning and I was like, I'm kind of in the mood for some search and seizure. So I'm sitting here in my closet drinking my whiskey and we're going to talk about a guy named Ted Chimel. The case is actually Chimel v. California. And when I was in law school, we learned this as the wingspan case, but I know some people discuss it as the incident to lawful arrest case, which also came up with a rule named after it, the Chimel rule. So let's go ahead and let's see what the hell happened. So back on September 13th of 1965, turns out that Ted Chimel had been a rather naughty boy, and 3 officers showed up at his house with an arrest warrant because he was wanted for burglary of a local coin shop. The officers were very, very polite. They walked up and knocked on the door. His wife answered the door. They ID'd themselves, asked if they could come in and wait. She decided that letting them in was something she was going to do, and so in went the officers. Ted came home from work. He got arrested. And at that particular point, things took an interesting twist. So the officers asked Chimel whether they could have a look around his house. He said no. Now the thing is the cops are always allowed to ask. There's nothing that prevents them from asking if they can look around. And there's nothing that prevents you from saying no. But here, because the officers said that the search was going to be on the basis of a lawful arrest, that they didn't really need his permission and were going to search anyway. Please do note, what they had when they came to the house was an arrest warrant, not a search warrant, and they certainly didn't have a search warrant for the house. These 3 officers then went about searching the whole house. Chimel's wife was following around behind them, and the officers were directing her to not only allow them into rooms, but that she needed to go and open certain drawers, cabinets, chests, things like that for them to look into. The officers collected objects as they were going around, generally related to the crime that he was accused of, so things like coins, medals. The whole thing took upwards of an hour. Chimel was put on trial for the burglary, and the objects that the officers had collected from his house during their search were used against him at that trial over his Fourth Amendment arguments. At appeal, the court even agreed that the arrest warrant was invalid because the affidavit that had been used to issue that arrest warrant wasn't quite right. But because the officers had gotten the warrant in good faith, they had sufficient information to constitute probable cause for an arrest. The arrest was therefore lawful, and therefore the search of the whole house was lawful and justified, despite the lack of a search warrant, because it was incident to a lawful arrest. That is a workaround and an end run that is really quite something to behold. Obviously, Chimel disapproved of this particular line of thinking and appealed the case, and it ended up at the Supreme Court. For their part, the Supreme Court took the initial hypothesis, the initial position, that the lower court was correct when they said that the arrest itself was valid. They didn't bother touching that particular part of the case itself. Now, given this is a search and seizure case, the judges took a look at the Fourth Amendment cases, many of which we have been discussing. Specifically, they started with Weeks. Now, for purposes here, they actually looked to the dicta of that particular case, which said that a warrantless search incident to a lawful arrest can be acceptable, but the search has to be limited to the person for purposes of collecting evidence or crimes. Now, dicta is an opinion, basically, issued by the judge, but it's not the binding precedent in the case, so it's usually something related to but not directly on point. So for purposes of Weeks, which was the exclusionary rule case we talked about, discussing what is and what is not appropriate for a warrantless search incident to lawful arrest wasn't really the issue, but it crept up. The court then took a look at the string of cases that came after Weeks that tended to expand this concept of what was appropriate due to an arrest and a search lawfully incident thereto. And yes, I said thereto. First, it went from just the person to the person or in his control, to the person in his control and the place of arrest, and then place of arrest got turned into possession or under control for purposes of the area. And as a general proposition, these searches were being allowed on a policy ground that's generally for purposes of officer protection or the destruction of evidence. So they don't want an officer trying to arrest somebody who is carrying a .45 in their back pocket and the officer gets shot because they didn't search the person or, say, the side table right next to them as they're being arrested. Same thing if you're carrying a dime bag, they don't want you being able to ditch it down a storm drain because they weren't allowed to search you as they were arresting you. But also in terms of policy, the court looked at the other side and said that wherever humanly possible, it's always going to be better to have a magistrate or some other kind of judge issue a search warrant wherever possible. Police officers are in the profession of ferreting out crime. It's their job to get the bad guy. So you don't really want them being the front line decision maker on when and when not a search is an acceptable thing. It's better to have a neutral third party look at all of the facts and make that determination. It's the easiest way to protect the constitutional rights of the citizenry. And this particular desire to protect that Fourth Amendment is largely grounded in the history of our colonial period, where the British government had a rather nasty habit of just issuing general warrants and government officials coming in and searching through everything you own, violating your privacy and intruding in that fundamental way. As a result, the court says that where a police officer wants to engage in a warrantless search, the officer has to be able to show that there's some kind of exigency in the situation that makes that search imperative. And so looking back again at the policy reasons that I mentioned earlier, destruction of property, destruction of evidence, or a weapon in terms of officer safety, the court said that it didn't matter how well-founded a belief an officer might have, that they think there could be something concealed in a home doesn't justify the search of a whole house without a warrant. And so then looking at reasonableness for purposes of the Fourth Amendment, the court said that looking at these policy concerns and the history, it's reasonable for an arresting officer to search your person when you're arrested to remove weapons and other things that could be used to harm them or resist. That's to protect the officer. It's also completely reasonable for them to do a quick search to make sure you don't have the ability to destroy evidence of your crime. And then they said that it's also reasonable that the officers should basically get to search the area in which the individual being arrested might reach to grab for some weapon or evidence. Because again, you might be able to destroy the evidence or you might be able to reach for a weapon and harm the officer. And so the rule they set out is that it's justifiable to search the person and his immediate control, which constituted the area from which he might be able to gain possession of a weapon or destroy evidence, or his wingspan, which is why we called it the wingspan case in school. That does not, however, give the officers the right to search other places. You don't get to go digging around in the attic looking for things absent a search warrant when you arrest the guy in his front foyer or the living room. The two have nothing to do with one another. They also made a point of highlighting that the wingspan rule is put into place, honestly, to protect the citizen to a degree. It's to keep the officers from preferring to arrest you at home just so that they could gain access to your house. The court said that it would be a small consolation to know that your papers are safe in terms of Fourth Amendment protection, only so long as you're not at home. The use of this particular rule disincentivizes police officers from scoping out your house and intentionally choosing to wait till you're home to arrest you. So what does all of this mean for Chimel? Well, it means that they reversed his conviction, because what they ended up doing was searching far beyond his wingspan. They went through every room of that house, into his chests and drawers and desks, all areas well outside his wingspan, all without a search warrant. As such, the officers violated his Fourth Amendment rights. In doing so, the court found that where you want to arrest someone in their home, if you want to search the rest of the house, you have to get a search warrant. So that was Chimel. Let me know what you think down in the comment section below. Is the court's rationale regarding wingspan reasonable? I tend to think so. We do need to balance things like officer safety. Last thing you need is somebody in handcuffs reaching, grabbing a gun out of their back pocket. But at the same time, where you don't have a search warrant, you can stay out of my underwear drawer. But do reach out and let me know what you think about the case. And until we are together again, I hope everyone is well.